the teamwork, the recent research about the traceability, legal interoperability, especially focus on digital product passport. And please allow me to share my screen. So let me share my screen. So can everybody see? No?
No.
Stop share. So let me share again. So now can you see my slides?
Yes, we can.
Okay, wonderful. So I use the display mode. So
Yep.
can everybody see me? Okay,
Yep.
wonderful.
Perfect.
Okay. So a little bit about me. I'm an academic. Originally, I come from China. I got my education at the Duke University in the United States. And I also had research experience, especially in Germany and Netherlands, a little bit in France. And so after that, I returned to China. I worked in China for several years, and then ultimately my whole family emigrated to Australia. So here I am in Sydney, Australia. I'm the Associate Dean and Associate Professor of Sydney Law School. I'm very proud that I'm the UNECE, United Nations Economic Commission for Europe. It has a United Nations Center for e-commerce and trade facilitation. So I'm the co-lead of the critical mineral traceability and sustainability projects, and also regional rapporteur for the Pacific. Today, I mainly talk about the white paper on digital product passport and interoperability issues. And this white paper has been published, so you can scan the QR code and access the white paper from the UNECE website. As Adelina just now mentioned, the white paper focuses on critical raw materials. However, it also has broader implications for other industries, products, production, where the DPP may be applied. Also, this conversation, I hope that it will also be a good opportunity that I can learn from you. As I'm an academic, I'm really eager to understand the issues, the challenges in industry, in your practice, so it can become the issues for me as an academic I study in the university. And the key findings of this UNECE white paper, and the digital products passport should be designed to facilitate the easy tracking of products or production and the sharing of information across international and multi-sector value chains. So as I highlight, it should be the easy tracking of products and production. Because one of my research methodology, so I have a team of scholars here in Sydney and also by the UNECE, it facilitates the joining of UN CFAC experts from around the world. So we consider that the DPP should not become another very costly, complicated compliance tools. Instead, it should facilitate the easy tracking and cost-effective tracking of products and productions. So ideally, DPP should help track the province where the product comes from, the country of origins, and also help track the products, the movement of products from the raw material, semi-raw material products, and to the recycle, repurpose, and refurbish. And at the end, it should also help to track the productions. And the share of information, here we focus on the digital traceability across the international and multi-sector value chains. The so-called international, it has the implications of conflict of law. It has the issues of different jurisdictions have different law, and the consequence, complexity and uncertainty for the business. And also it increases the cost for the regulators. Later, I'm going to further elaborate the uncertainty, inconsistency, conflicts, or competing regulation issues. So the DPP should not be a trade barrier. It can be used for sustainability and circularity as it was designed by the EU eco design regulation and the battery regulation. However, because the white paper also covers other jurisdictions, United States, China, Global South countries, and we consider that DPP and other traceability tools should also be designed to facilitate other compliance concerns like anti-dumping, like a tariff, especially for the US market, and the sanction issues, especially like for issues in Russian, and Russia is a very important critical raw material countries. And there are other sanction issues. China also imposed sanctions, and most recently regarding the constraint of the rare earth and the digital products passport have the potential to facilitate companies, regulators to avoid or to comply with all those regulations. The second key findings, this is not a positive issues. Why? Because different DPPs and traceability system in the EU, China, and the United States, the big three jurisdictions, and the Global South countries lack interoperability. Our research started from compare different DPPs. We know that in the EU, the DPP is based on the law, so it will become a market entry requirement starting from 2027, and the pilot industry, including batteries, electronic products, and just now at the beginning, while waiting for the beginning of this conversation, I had a little bit of chat with attendants. Also like textile industries. However, besides the EU DPP based on the law, there are other DPPs applicable in the markets. So for example, the Global Battery Alliance, early in 2019, it has launched the GBA, Global Battery Alliance Battery Passport. Also, more recently, United Nations, UNCFAC, and UNECE, they launched the United Nations DPP. What are the differences? There are two major differences. The first one is the legal foundation. And the EU DPP is based on the law. It must be complied starting from 2027 for the products to enter the EU market. However, for the UN DPP and the Global Battery Alliance DPP, they are more voluntary. And also in the second difference is regarding the scope of application. For example, the UN DPP have a broader scope than the EU DPP by including commodities, materials, and consumer products and services. Global Battery Alliance DPP, as its name indicates, restricted to a certain market. So the second part, I think is more severe problems is the lack of interoperability between different DPPs and other traceability systems. Especially you look at the three big jurisdictions and the number of smaller jurisdictions in Global South. So let's start from the EU. The underlying policy reason for DPP is for circularity, sustainability. However, if you look at China, China is quite interesting, as I use the examples of critical raw material, especially we focus on 4 critical raw materials: copper, cobalt, lithium, and nickel. And we also look at the textile industries. So China's traceability system is bifurcated. So it has a traceability system for domestic consumption, domestic use. And you also have a traceability system for exportation. So if you look at the domestic Chinese traceability, for the example of the battery for electronic vehicles, so the domestic traceability system is focused on sustainability issues, especially for recycling of batteries. However, different from the EU DPP, the China domestic traceability system for batteries does not trace from the mining preliminary processing. It's more focused on recycling of the batteries. So as we know that in the EU, the DPP is supposed to trace from the mine to the first consumption, recycling, refurbish, repurpose, and second consumption. And China also create a different traceability system for exportation of batteries. So this exportation-oriented traceability system is currently under development. It targets for different markets. So for example, for the EU, so they try to connect with the EU DPP or, oriented for traceability for the purpose of sustainability or circularity. However, for the United States, it will be more oriented towards the country of origin for the purpose of tariff. So regarding textile, and China's traceability for textile industries really lag behind compared with critical raw materials. I think the reason is critical raw materials has much more potential for recycling compared with textile. Of course, textile can be recycled, but critical raw materials certainly has longer lifetime for recycling. So China's traceability system, as you see, is industry-based. This is also different from DPP in the EU. It's supposed to be created for multiple industries. Now we look at for the United States. US created another very interesting study example with the change from the earlier Biden administration to the Trump administration. So I even have to rewrite our draft, for the publication of the white paper because of the Trump administration. So currently, the US traceability system largely focuses on tracing the country of origin for the purpose of tariff, to safeguard the geopolitical security, to increase domestic production, to ensure human rights and other ESG compliance. So it has, people here may be familiar with the United States Inflation Reduction Act, which was initiated by the Biden administration, and currently it is still, implemented. So it is a combination of everything, combination of sustainability purpose, of the geopolitical tension issues, like a bigger hot pot. And the US reciprocal tariff vary from country to countries. This provides incentive to circumvent high tariff by supplying US from other states. So the US traceability system, it tracks the country of origin of products It really is a focal point for even focus on, for example, the steels, the material, it tracing requirements on the province of steel entering the US from Mexico and Canada. Another example in the US traceability system is the CHIPS and Science Act for the CHIPS, of 2022. It emphasized domestic sourcing and security in semiconductor manufacturing. Okay. Another example, as I mentioned, is Inflation Reduction Act. So if we put EU, China, and US together, you find that they do not really talk to each other for two reasons. The two major reasons, there are a number of other minor reasons. The first reason is the underlying reason for the legislators are very different in these three jurisdictions. And the second one is their regulatory method. So the EU implemented the eco-design regulations for multiple industries. So as Adelina invited me today to talk, she especially reminded me I should not only talk about the one industry critical raw material. I need to do homework for multiple industries. And China, as you see, United States, they are industry-based regulation. Like the US for semiconductor have its traceability system. China for critical raw material has its own traceability system. Also for China, it's bifurcated domestic traceability system. It highlights environmental protection, recycling. For exportation purpose, it targeted for different exportation markets. Okay. So US, it really depends on who is in power to decide the focus of traceability. Regarding global South countries, and the problem is global South countries, they either have no domestic indigenous traceability system, and the second is they have to comply with the multinational companies. So there are pros and cons, for compliance with the higher standards. But overall, it created confusion and increased the cost in business compliance. So the key finding and solutions to the problem, the gaps we identified. So the team argued that we can leverage existing legal framework. So we started from existing legal framework from trade. So the one example for trade is the WTO legal system. So regarding the TPP system, so the highlight is the DPP should not become a trade barrier. It actually should be used to facilitate the trade rather than become a trade barriers. Also, there are industry standards like UNEC and UNECFAC standards. And the team also look at the white paper also covered like ISO standards and GS1 standards as well. So going beyond the law, the international treaties, which is the so-called positive law, because if you violate it, you get, the penalties. We also have industry standard, which is voluntary. And the last one, we should not ignore the United Nations Committee for International Trade Law, the UNCITRAL. So UNCITRAL has a number of existing model law. So for example, under UNCITRAL model law on electronic signatures, the Electronic Communication Convention, and also more recent regarding the trust issues in the value chain. So the three very important digital traceability principles: technology neutrality, non-discrimination against the use of electronic information, and functional equivalence. So regarding transportation, when the products or the raw materials and the semi-raw materials move across border, always have transportations. So here the white paper covered the United Nations International Maritime Organizations that have conventions, codes, and regulations. So for example, the International Maritime Dangerous Goods Code, especially, regarding the lithium batteries and other hazardous products, the traceability system. So also have international maritime organizations to port state control, and also international convention for safety of life at the seas. So all these maritime related conventions actually support the transportation and relevant traceability. So going beyond the maritime transport, we also have Basel Convention on the control of transboundary movement of hazardous waste and their disposals. And further, ancestral model law on electronic transferable records, so digitally transferable, and the model law on electronic transferable records. Okay, so all these model law or conventions, it will support the digital traceability. And then finance and others. So the existing legal system include the international financial reporting standards and sustainability disclosure standards. And ISO standards also provide both a general framework for key chains of custody models and specific traceability requirements, etc. Also, we have, the Clean Economy Agreement signed under the Indo-Pacific Economic Framework, which only briefly talk about the modern slavery issues. Okay, we also have principle on business and human rights. So as we see, actually existing legal frameworks, they are piecemeal, fragmented international laws. So here, the so-called international laws, we have treaties, we have industry standards by GS1, by UNCFACT, also by ISO. We also have industry-based, like transportation, maritime. We have, focus on hazardous products. We have digital transferability, like transferable records, etc. So the issue actually is, when you look at the DPP, it links from, using critical raw material as an example, from the mining country like Australia. And then you look at the products, and the minerals move, and the midstream value chains is either in China, in Japan, in South Korea, or in Indonesia, Malaysia. And then the final consumption countries, United States or EU or UK. So in this value chain, the problem is the currently fragmented existing legal framework. How can we make it as a whole to facilitate the whole value chain, cross industry, cross countries, so the relevant data can flow from the beginning to the end to ensure sustainability and verifiability of the value chain? So I have some preliminary solutions here. The team has a preliminary solutions. So for private entities, so the suggestion is, when the products and the relevant data move across the value chain, it's necessary to respect the mandatory law and public policy exceptions in the individual countries of your factories. So here the argument is, although the value chain may have to ensure the final products comply with the market entry requirement of the first consumption market. However, for each individual jurisdiction in the value chain, their mandatory law and public policy exceptions should be considered. The mandatory law include, like, the labor protection issues, like environmental protection issues, and like data protection issues. Also regarding maintain certainty and predictability, here the issue actually is recently I came across a very interesting case regarding the fraudulent issue in value chain and the dispute resolution. So in the dispute resolution in the value chain, the commercial parties prefer to use arbitration. But remember, arbitration is based on contract, based on consent. So if the flaw does not occur between the immediate contracting parties, it's from your upstream value chain or the downstream value chain. It's very hard to bring in the upstream and downstream into the arbitration because you do not have the contracts to get their consents into the arbitration. So the maintain of certainty and predictability is indeed a big issue for the in-house lawyers, how to draft your dispute resolution provisions. Okay, so if you have questions, I'm really happy to further discuss. So this is an example of the lithium value chain. So my team, used the biggest suppliers, the mining in Australia, and then you have the processing in China for the export to the European Union or the United States. Now it's very hard for China to export the battery to United States, okay, but in the past it is possible. And also the recycle also is a very tricky issue. How to ensure the traceability of recycle, and also which law should be applied to the recycling industry if it is offshore recycling. This is mapping indicate that the mandatory laws in different jurisdictions. So the takeaway from this mapping is the challenge for the upstream and middle stream value chain participators. They not only have to comply with the downstream market regulation, they also have to comply with the mandatory law or public policy exception in their own country. So this indeed increase their compliance burdens and cost. So the white paper also discussed the micro perspective from the party, the immediate party for export into the EU market, using the digital product passport as an example. So you have EU importer contracts, non-EU battery manufacturers for EU DPP, and then product shift. And then here you know the entry point to the EU market, you discover fraud, and there is penalties and liability or sanction. So it looks like the EU law only apply to this is the exporters or the final products makers, but actually not necessarily. The team find that with the implementation of the digital product passport, the upstream value chain, like the mining companies in Australia or in Chile, in Congo, because they have to surrender their data to the digital passport. So this can enhance the regulatory power of the first consumption market, which is the EU market, to require the upstream suppliers and the middle stream suppliers to comply with the EU law. How to enforce the upstream and middle stream who do not have immediate contracts with the downstream market. So you see this, the micro perspective, all those parties, they have immediate contracts, but the upstream and this part of the high end of the middle stream, so they do not have immediate contract with the downstream market. The enforcement can be done through the the tort, the tort, in the dispute resolution, you bring the case in tort. So like the NGOs, consumer groups, etc., they may bring the litigation against the upstream suppliers based on tort, without the contracts. However, the problem is, for the academic, I'm not sure whether my concern is really true, is really a practical issue. So I have two concerns. So the first concern is for the recycling. Which law should apply for the recycling industry? So the connection of the DPP from the first consumption to the second consumption, especially when you consider the critical raw materials, it may be recycled to make other products, or the textiles, it may be recycled, resold to a market without the DPP compliance. So the connection between first consumption and recycling and the second consumption. And the second concern for me is regarding the upstream. So I'm not sure that it is a good idea for the whole supply chain to comply with one law. There are benefits. So for example, it's consistency, this is efficiency, and everybody comply with the highest standard. But there are problems. First is there are multiple markets. As I mentioned just now, currently the upstream and the middle stream supply chain, they have to comply with the different traceability requirements in the US, in United States, or if they would like to export to China, they have to comply with the China traceability system. So there are different markets. For different traceability, it increased the compliance issues. Okay, so I'll quickly finish. And then other key findings for policymakers. So my suggestion is need to ensure inclusivity and support for small, medium enterprise and developing countries. So especially small, medium enterprise. So the team, including me, we have research interviews. We conduct a research interview in Australia, in Indonesia, in Japan. We have people go to Japan and China, and UK, United States, and France, and Italy. So we find that the problem for small and medium-sized enterprises, the PPT may create a monopoly because if it increases the compliance cost. So like we have a conversation with some Japanese experts, and they think the large Japanese companies, they have concerns about the reputation damage. So they will look through their supply chain to ensure that everybody in the supply chain can comply with the high standards. So this actually reduce the business opportunity for small and medium-sized enterprise. The problem also exists for developing countries. So the advocacy from our academic, me and my team, is we suggest they should build a mutual recognition of regulatory outcomes across the jurisdiction. Something like the adequacy and decision regarding the data transfer, like the EU and Japan has the adequacy decision. EU, Korea, there is an adequacy decision regarding data transfer under the GDPR. However, EU does not have an adequacy decision with Australia and with China, and these are all bigger players in the international value chain. So what's the next step? So for SMEs, so Adelina, do you want me to continue with the next step, or you want to jump in, ask questions, or we open up conversations?
Well, I think you should wrap up this slide and then we'll open it up to the floor.
Okay. So for the SMEs, so the team's suggestion is there is 3 parts. So actually SMEs have to, really form the international organizations. Industry organizations need to advocate for training support, funding support for SMEs, especially in global South, to be familiar with the EU DPPs or other traceability tools in the downstream markets. And the second suggestion for SMEs is it have to partner with the multinational companies to join their value chains. So the last one for SMEs, and I think SMEs is in a difficult situation. So, so for domestic governments or international organizations, like every time UNEC invited me to do presentation, I always talk about the trainings, the fundings need to provide for SMEs to make a digital products passport or other traceability tools easily accessible, easily to use for SMEs. Regarding manufacturers, so here the manufacturers, it really depends on whether the manufacturer is in the upstream or the middle stream. So remember our micro perspective, this is the manufacturer, but you also see the manufacturer in the, the upstream or the high end of the middle stream. So I think for the manufacturers, they need to pay attention to what is ongoing in the downstream markets. But the problem here is like I have research interview with the Australian mining industry. They may not care about the downstream market. Why? The first reason from my legal lawyer's perspective is there is no direct contracts. Right, for the upstream, especially the difference between textile and mining is the upstreams is typically the bigger companies. Of course, it depends on different critical different raw materials. So some minings like iron ore, you have huge large companies, but for like nickel, like lithium, actually it's the junior mining companies, not really particular bigger ones. But mining companies, they have large negotiation powers, so not really care about the downstream markets. The textiles are very different, especially the farms, typically like in Indians, in those developing countries, they have less negotiation powers. Okay, and also you look at the middle streams, are quite a difference. It depends on whether there are direct contracts with the downstream markets, which impose the DPP. And then for the DPP service providers, I think there are 4 keywords really for DPP service providers. One is transparency. Second is privacy. Third is security. And the last one is business confidentiality. I always argue that there are tensions between these 4 keywords. In my interview with DPP service providers, and I asked them to draw pictures about the relationship between transparency. DPP hope to enhance transparency, but the transparency for the downstream market is in tension with the privacy requirements, the data protection issues. You look at the upstream and middle stream value chains. Why? Because many supply chain participators, they may be individuals, right? There are employees, information, etc. And also security. Security has twofold meaning. First one is technology security, right? The data should not be tainted. The data should not be leaked. However, currently there are more and more national security issues. Especially, I think DPP should not be designed only for one market. It should be, interoperable with other markets like the United States. They care about the national security issues. And China, for some industry, they also really care about it. So security. So the last one is business confidentiality. So in my interview, so many business partners told me that they don't, no, there are many informations they do not want to surrender. So how to really balance these four, these four concepts. So I understand that, like, I work with the technology-oriented colleagues, and they told me that there are credentials. There are also, all kinds of technology means to ensure that different stakeholders in the value chain can have different access to the data. And domestic policy makers, I think also depends on which jurisdiction they are. For the downstream market, for the EU domestic policymakers, I think that they really need to pay attention to the thoughts from the upstream value chains. So in a recent paper that I co-authored with my colleagues, we argue that from centralization, the whole supply chain is subject to EU law to mutual recognition. So we develop models of mutual recognition. We think the mutual recognition started from bilateral to regional to mega regional, and then ultimately, hopefully, can go to multinational. So we built up models with reference to existing mutual recognition system. For example, for mutual recognition of marriage certificate, mutual recognition of university diplomas. You know that currently we have the so-called apostille convention, which include more than 100 countries to mutual recognition your driver license, mutual recognition of your marriage certificate. So why the mutual recognition of this type of certificate cannot, insights or lessons for mutual recognition of ESG certificates? And then international organizations and universities, international organizations like UNECE, is certainly play a fundamentally, tremendously important role. Universities like me as an academic, I hope to learn the problems and challenges in the industry, so it can become my research subjects. So the PhD students I supervise and my colleagues, the UNECE experts, we can jointly, find out the solutions for the industry and regulators. So yes, this is the end.
Wow. And I thought 20 minutes. It was absolutely fantastic. I'm hopefully,
yeah.
I absolutely hope everybody else enjoyed it as much as I did. I didn't realize it was quite so complicated, but Jeanne, it is. So we're going to open up the floor. If you have a question, just please put your hand up or just jump in and ask a question. Does anybody have, okay? Caroline?
Hi, can you hear me?
Yes.
Great, thank you. Thank you for your wonderful talk. About mutual recognition, I would like to have more information on what this consists of exactly. The examples that you gave, driver's licenses, marriage certificates, these are documents and possibly digital documents that are created by administrations, right? Therefore, the trust level associated with this data is high because we can assume they've been generated by organizations that are trustworthy. With the topic of the DPP, this is less so because we have less trust of the data. And therefore, I was wondering, what are the limits of mutual recognition in this context? And if mutual recognition, you mentioned digital tools like verifiable credentials and things like that. If mutual recognition could legally extend to the concept of root of trust or trust anchors.
Mm.
Trust anchors for data.
Mm. Yes. So Adrina, maybe you can help to circulate the paper that I email you before our webinar. So where we argue there are 4 models regarding mutual recognition. So I fully agree with you. The example I give you that is the public documents, right? Marriage certificate, public documents. But in our paper, we also look at the other existing mutual recognition system. So one example is the arbitration award. So arbitration award is issued by, it can be ad hoc arbitrator. Like Caroline and me, we agree that we are going to ask the, I'm the buyer, you are the seller in international trade, and you are not happy with my products, and you think, it's not organic cotton, for example. So if we jointly trust the Adrina, we ask the Adrina to be the dispute settlement person, the arbitrators, and then at the end, the Adrina to issue an arbitration award. So internationally, there is a convention called the New York Convention. It has more than 130 member states. So the mutual trust has been established is for the country to enforce this award, they will only look at the procedure issues rather than review the merits. And there are a number of exceptions. So what our paper is a long academic paper. I hope it's not the academics' imagination is. We fully agree that the trustworthy issues, is indeed a problem, but there are ways to build up the trust. The first step is, maybe people do not like me talk about it. So the first step actually is the friend sourcing. You sourcing with your friends, the friend sourcing or the ally sourcing. So for example, if the 2 countries, they trust each other, so a bilateral mutual recognition agreement may be concluded. And this, the reason why I think maybe people disagree me, because the friend sourcing or the ally sourcing may be argued against WTO law. WTO is, also against some free trade agreement. However, the mutual recognition have to be established between the countries or the industries. They trust each other. The enterprise, they trust each other. So the first step need to, like the adequacy decisions by the EU. So EU is not establishing adequacy decision under GDPR with every country. They start with their allies. So I think this should be the first step. Bilaterally, and then step by step to expand it into multilaterally.
Okay, sorry, we have other questions. I know it's a great topic. I'm sorry to interrupt you. I will send out all the white papers that Jeanne has published for everybody to have a look when I send out the links and a copy of the presentation. So we just need to move on to the next question. Sohang, would you like to ask your question?
Hi, Adriana. Thank you so much. Hi, Jeanne. And it's not necessarily a question, but maybe an extension of the comments that has been made so far. And going back to what Caroline was saying, I mean, there are 2 different kind of aspects to it. You have the governments and public organizations who are doing a tremendous job in terms of when you look at what's been happening in Europe specifically, right? And the BATPass or Battery Pass project that I've just mentioned in the comments as well, you can see how much work has been done to actually align the whole industry to think about, okay, what sort of data do we want to publish as part of a battery passport? And they've also looked at all the different regulations and basically annotated which ones are mandatory, which ones are optional, right? So if you think about different companies looking at it differently, but as long as they are following, okay, what's mandatory will include and what's optional we will not, or we will basically play with that, you still have some sort of kind of interoperability, right? Within that. And then you look at the private sector as well. I think that this whole question about trust also comes with the brand value. So, we tend to believe some brands have, more reliability than others, for example, right? So, that also comes into the picture. So, private sector will also have to work kind of hard to build that trust with the consumers so that whatever claim they're making is trustable, and then people tend to just, take it, for granted. But the other thing is, how do you kind of combine them too? You know that in Europe, there will be a central registry of all the digital product passport, for example. And I'm sure at some point, Caroline, you will probably agree to that as well, that there will be some specific rules and regulation that every single passport will have to follow to be, registered on that registry. So if you have a product passport, be that a textile product or a battery or an automobile, as long as it's in the registry, maybe that will add to that trust as well, which is the kind of conversation we've been having in the last few minutes.
Yeah. So may I ask you a question? This is also from my interview. So in Australia, in Sydney, every year we have a big mining industry expo. So all the industry they connect with mining, they will come here for exhibit. I think that the issue is in terms of consumers. For the textile or the coffee, the consumers, they care about the claim, whether the claim is reliable or not. However, if you look at the mining or maybe electronic products, right, the final consumer may not really care because the mineral has changed, by the processing at the end, they become either battery, become mobile phone, become a computer. So the question is whether the consumer really care. And the second issue is from our interview in Japan. So the question is whether consumer understand. I'm is currently in the upstream and the middle stream of the value chain. So my question actually is for you, if you are in the EU, whether consumer will understand, right?
Yeah, I mean, and that's something that, both the private sector as well as public bodies are taking very serious. For example, my company have been involved in, advising sessions with the UK government's policymakers, where we talk about, what sort of policies we can bring about when it comes to digital product passport, following the EU regulations, but at the same time, how do we build awareness? And I think the whole industry has some role to play, the solution providers, the brands. We can run pilots, we can run awareness sessions, webinars, and, like today's sessions that you're running, right? Because we are also consumers, right? Although we do, business in sustainability and the circular economy industry, but we're also consumers. So I think it also helps. The more we do these things, the better it gets.
All right. Thanks, Sohan. Shah, would you like to ask your question?
Yes, thank you. It was a great presentation, Jeanne. I just wanted to ask you, in relation with the DPP implementation to GS1, do you have any extended research on that, like how it will be implemented and all other things with private sectors or EU?
So just now you mentioned ISO and GS1. So what I know is UNECE currently has a joint research group, the UNECE and ISO. They aiming to make a DPP industry standard. So I feel I'm very honored. Actually, I have been invited in last July, several months ago in Geneva. So they had a meeting, a webinar for 3 days. They have to cope with different time zone. So I think currently that UNEC and ISO research group, they focus on 3 major industry, the 3 pilots in the EU eco design, which is the battery, textile, and electronic products. So the goal is to issue a industry standard in this regard. Regarding GS1, I'm not really expert here, but I know that the GS1 also do a lot of work regarding, you see the barcodes. So I, in my class, to help my students understand the difference between the GS1 barcode and the DPP is actually the barcode does not talk to consumer, right? We can't scan it. We don't have a machine to scan the barcode. But the purpose of the DPP is to enable consumers. And I think this is very important. Also, this related to my comparison study between EU, US, and China. You look at China and US, their traceability system typically not talk to consumers. It's more about the B2B and B2G.
Okay, so anybody else has a quick question? One more question. We'll do one more question before we wrap it up for the evening or the day, depending on where you are. No, if you want to ask a question, please write it into me. I'll put my email address in the chat. So I'm Adriana at circulareconomyasia.org. So please feel free to send me if you have any questions or would like to have any other information in regards to this webinar or this discussion that we've had today. And as I've written in the chat, that will send out a copy of the link to today's discussion, plus Jeanne's work and a copy of the presentation. But that'll be enough for another couple of days. So I hope you enjoy it, and there'll be many more discussions and conversations with other people over the coming months. So thank you very much for your attendance, and we look forward to seeing you all again sometime soon in the future.
Thank you so much. So please do not hesitate to reach out. I'm an academic, so my research topic is from you. If you have industry issues and you think, academic need to think about ways to as a bridge to connect the industry and government with creative ideas. So really, please do not hesitate to reach out. So I know that my idea is not just my imagination. It is from you. You are real people, in the industry. Thank you. Thank you.
Wait, we've got one last question, Carolyn.
Just a small comment to Jeanne. If you want to use the Cirpass2 stakeholder group, because there's several hundreds of experts and service providers and from many different industries, if you believe that this would be useful for your research, please let me know.
Yes, I will. It is very helpful, like the question you asked just now, I take down the question. I think this is important regarding mutual recognition of the trust anchors. Yeah, this is something I need to think about. Yeah.
So I really want to thank Jeanne for a fantastic discussion today, and it was unbelievable. So I was very pleased, and so thank you again, Jeanne, for agreeing to this talk.
Thank you.
And I'm signing off from the Cirpass2 Interoperability Working Group.
Okay.
Bye for now.
Bye-bye.